This morning, there's a few topics that's going to be covered by our presenters, and it gives me great pleasure to introduce them. Firstly, Lizelle Kilbourn, who has been a practicing attorney for more than 30 years. She qualified and did her articles at a law firm, which is now the largest law firm in Africa. Her primary focus is on research and education, with a specific interest on sectional title law, if I may say that. She is the co-author of, which in my opinion, is the best conveyancing textbook out there at the moment, called the ABC of Conveyancing, and used extensively by law students around the country. She's also the co-author of a publication called South African Legal Practice. And we are very pleased to have her as a consultant and work in conjunction with her on various projects.
Sectional titles, STBB is doing a
Our second co-presenter is a fellow director, Maryna, who also heads up our marketing department. In addition to her various tasks, Maryna is an extensive publisher and lecturer for STBB on various topics, and in charge of our knowledge and research. I think that the pieces of legislation that will be discussed today, you'll find interesting. No doubt it is going to affect the manner in which we do our business, which is sectional title development extensively, and also just to avoid some of the pitfalls when we progress and do these developments. I look forward to enjoying the session with you. I hope you find it insightful. And most importantly for these sessions, please provide us with your feedback, as we hope to continuously roll up these educational courses throughout the year. So please have an enjoyable session. Thank you very much.
Thank you, Darren. Good morning, everyone. It's really lovely to be here with you today. Darren, thank you very much for that introduction. We appreciate that. And without further ado, we are going to dive into our seminar. The proceedings are going to be for approximately 1 hour. And Maryna and I thought that we're going to spend, if we can time it that way, about 40 minutes on the sectional title aspects. And then we're going to spend last minutes on the topics that she will address. And we will also, if time permits, allow some questions. Of course, you're very welcome to post questions in the meeting chat. There might not be time to answer them all, but if necessary, we will then answer them separately afterwards. The PowerPoint notes that we are going to use for the day have been set up in a way that they serve both as a guide for us during this conversation, but also as semi-complete notes for anyone who's interested in having the notes and perhaps referring to them back at a later stage. And you're welcome to contact us, and it will then be sent to you. So without further ado, let's go into our session. As you know, today's talk is primarily about the Sectional Titles Amendment Act 13 of 22. The Act was assented to. I'm not sure if the slides are being shared at the moment. You'll probably have access to them in a minute on the screen. Okay, can everyone see them? And it came into force, as you know, on the 5th of January 2022. A total of, depending on how you count, 39 or 40 amendments have been made to the Act in this way, to the main Act, the Sectional Titles Act, and it affects 16 of the sections in the Sectional Titles Act at present. There's also been a Chief Registrar's Circular that has been issued, which is really of interest to conveyancers, and it gives some information about the registration-related aspects of the amendment. Just as a matter of interest, we've had a question before the seminar. There are some young candidate attorneys and other conveyancers that intend to write the conveyancing exam within the foreseeable future. We think that these, from a registration point of view and from an examination point of view, these amendments are important. So I hope that those that are preparing for the exams will also find the seminar useful in understanding what they relate to in terms of conveyancing material. Right, just a brief overview by way of introduction. Section 1 was amended. There's an expanded definition of exclusive use areas and an updated definition of the STSMA. We'll talk about the first one. Section 4 has been amended. Section 14, there were 3 amendments. Section 15B, an amendment 17, 18, 21, 22, 23, 24, 25, 26, quite important, 27, and then some minor amendments 32, 54, and 55. Now, most of these amendments are of a relatively technical nature, and they relate to registration procedures. And then many of those, as well as others, are intended to provide clarity on the law and clarity on procedures to be followed in terms of registration. Some of these amendments have a direct, but mostly indirect impact on developers, and also to a lesser extent on sectional title management, in other words, trustees and managing agents. But even though it's not that directly relevant in terms of what you as managing agents or you as developers are going to have to do, it is still important for you to understand what is happening here so that you can assess how it influences your particular spheres of management or operations. Few of the amendments really affect very minor things like he or she is added and descriptions of acts. We're not going to discuss any of those today. Some of the amendments address gaps in the law by spelling out procedures that was previously not catered for in the Act. As you know, a registrar of deeds and his personnel or her personnel only have those powers that are assigned to them by an Act. So if the Act does not make provision or gives authority for a specific registration procedure, it cannot be done. It's quite important that certain gaps had to be filled. And then some of the amendments import provisions from the Deeds Registries Act directly into the Sectional Titles Act to eliminate or limit the need for cross-referencing between the two acts. So who are affected? Mostly the registration authorities, the registrar, the surveyor general, also developers, you'll see in what way, conveyancers certainly, land surveyors or architects drafting sectional plans, lawyers or land surveyors that intend to write the exams, as we've said, certainly owners of sectional title units and exclusive use areas, and lastly, as we've already said, to a lesser degree, trustees of bodies corporate and also managing agents. So let's start with section 1. The definition of exclusive use area has been updated. Now, previously it read, it means a part or parts of the common property for the exclusive use by the owner or owners of one or more sections. So that is how we traditionally understand the exclusive use area. It's something that is reserved, it's common property, but it's reserved for the use of the owner of the unit. But what if that unit is let? Or if somebody else with the permission of the owner occupies the property? Could that person then not use the exclusive use areas? Well, the law was silent on that, so there was some debate. So in order to give clarity, the definition was augmented by adding the words or by the occupant or occupants thereof recognized by law as contemplated in this Act. So it's self-explanatory, and perhaps an applicable example is if trustees refuse a tenant to use a storeroom. Let's say there are storerooms, but they are exclusive use areas, and if they claimed previously tenants can't use it, it's only for owners, what would the law then be? So to provide clarity, that has now been rectified. Any person who is lawfully in the property, whatever lawful means, or in terms of whichever law, it could even include pi, I would imagine, although there are nuances, we can discuss that. Every occupant that's there lawfully may then also use the exclusive use area that is designated for the owner's use. 1B, there was a small amendment just affecting the name, so we're not going to talk about that. Section 4, there's been an addition to a definition. It's a minor, small, just 2 words added, 3 words added, but it does have a profound impact. although those developers that deal with this is probably a very niche market, so I'm not quite sure how many developers will really be affected in practice. It relates to existing residential blocks of flats, which are then developed, which are then sectionalized. So what does it mean, or what does the section say? Just some context so that you understand the amendment. As you know, the law protects consumers. Let's give an example. I'm 90 years old. I've been living in this block of flats and I've rented from the landlord for the past 50 years. Now the owner has sold the building and the new developer wants to sectionalize the building. I'm quite uncertain. I'm 90 years old. I'm not legally qualified. I know that in terms of the law, there are many hoops that the developer has to jump through, tick boxes, before the sectional plan can be opened. One of those is that a meeting must be held where lots of information are given to the occupants, to the tenants. The tenants may ask questions, the developer must answer all the reasonable questions and so on. But now I'm 90 years old and I don't I'm not comfortable with legal aspects, so what do? I bring my lawyer to the meeting. In fact, I don't even attend the meeting. I send my attorney to the meeting on my behalf. The attorney puts up her hand. She asks the developer some tough questions or interesting questions. The developer could then, before the amendment, theoretically, quite rightly say to that attorney, who is the agent, the representative of the tenant, I'm sorry, I'm not answering your questions because the law, section 4.3 of the Sectional Titles Act says that I must answer the questions of the tenants, the occupants. I don't have to answer your questions. Now, to provide clarity, the law is now changed by the addition of the words, and I'll just read the first sentence. A meeting has been held and the developer, so you can't, one of the things you must do is a meeting must be held. The developer has been available thereat to provide the particulars contemplated in the said paragraph and has answered all reasonable questions put to the developer by the lessees or their respective agents present. So it's a small amendment, and it only relates to a few developers, those who develop residential blocks, but it is of very important legal consequence. Okay, that is section 4. Now we move on to the amendment of section 14. There were 3 amendments. Just some context before we discuss those. As you know, the sectional plan, which performs the same function as a diagram of a piece of land, is, for lack of a better description, the legal foundational proof of the ownership and the rights of the owners, the holders of real rights, the holders of exclusive use areas, and so on and so on. It's very important that this plan that is registered in the deeds office and that is available as a public document for inspection is accurate, because people rely on it when they purchase, they rely on it when they decide to exercise a right of extension if you're a developer, and so forth. But what happens if it's discovered that a registered sectional plan is incorrect? I've given you some examples. Let's say that you discover all of a sudden, to your shock and horror, that there exists a unit in the scheme on the ground, but it has accidentally been omitted from the plan. Or an area that was designated an exclusive use area, you even have your notarial deed to prove it, somehow is not delineated as such on the plan. Or a unit is shown in a wrong position to where it was actually built, or maybe the floor area, the extent of the floor areas were incorrectly recorded on the plan. Now this error is discovered. So the law then, perhaps let's give a specific example just to practically illustrate. So unit 123-4 is recorded on the sectional plan as being 600 square meters in extent. Lovely large unit, but it's an error because it's actually only 60 squares. So it was a typing error. Now, I'm sure we can all understand that a prospective purchaser who relies on the sectional plan might be prejudiced because he or she is going to think he's buying a far larger unit rather than a smaller one. So how do you solve the problem? Well, Section 14.3, we're now looking at it first of all before the amendment, because the problems arise, says, if in the opinion of the Surveyor General, any person could be prejudiced by an incorrect plan, then he can advise the registrar, and thereafter the registrar will make a note and no transfer will take place until it is rectified, unless, and there's certain exceptions which you can read for yourself. But now, let's say the error does not relate to a section, it relates to an exclusive use area. Let's go back to section 14. We can take one on. If you exclude the red bits, which were the amendments, you will see that there's no authority for the Surveyor General or the registrar to then interdict transfer if the error relates to an exclusive use area. So all that the amendments to section 14.3 now do is that it now permits the registrar and the Surveyor General also, if there's an error in an exclusive use area, not only in a section, to then also stop transfer until rectification is done. So that in a nutshell are the important things in section 14.3. The amendment of section 14.5 follows on what we've just seen in 14.3. The Surveyor General, I'm now reading from the Act, the bullet points are just to break it up and make it easier. The Surveyor General shall advise the registrar and the local authority of any alteration, amendment, etc. that must be done, which affects the description or extent of any section, and consequentially the words or exclusive use area have also been added now, and thereupon the registrar shall make the necessary endorsements. So first you pick up that there's an error, the registrar then stops transfer or cession of exclusive use areas. The architect or land surveyor or body corporate, whoever caused that plan originally to be registered, then has to rectify it, and now the registrar has the authority to record the alterations, whether it's for sections or for exclusive use areas. The amendment of section 14.8 is the addition of a specific sentence. It says the provisions of section 49.3 to 49.5 apply with the necessary changes in instances where a body corporate is in existence upon cancellation of the sectional plan by an order of court. Clear to all of you? Sure, it must be clear as mud. So what exactly does this mean? Let's look at the context. First of all, let's look at what the purpose of section 14 is. Section 14 deals with various aspects concerning the amendment or cancellation of sectional plans. And when can a sectional plan be cancelled? And why would it want to be cancelled? Well, maybe you're a developer, you've applied for the opening of a sectional title register, you've had it registered, and after a while you decide there's too much slip, you pay levies to the CSARs, you have to have annual meetings, lots of things. So you haven't transferred any units, you decide, nah, I want to cancel. Or the buildings may have been destroyed, there's nothing left, they've been razed to the ground. Then there's a procedure in the Act, and we'll get to that, that permits the deregistration of the plan following certain provisions and processes. So there are instances where sectional plans can be cancelled, or where a developer or the owners themselves might desire to cancel. So prior to the amendment, which now becomes section 18, my apologies, I think I've had it the wrong way around. A sectional plan, the Act said, the section 14 said, a registered sectional plan shall, subject to the provisions of, and then it lists some exceptions, which we'll get to, only be cancelled by an order of court. So unless one of those exceptions apply, the only way in which one can cancel a sectional plan is by way of an order of court. And once that has been done, then the registrar must give effect to such cancellation, make the necessary endorsements, entries into his records in the prescribed manner, and then he or she must advise the Surveyor General, who must also then do certain things. But the Act did not spell out what the legal effects would be in the instances where the court orders cancellation. So there are procedures in the Act for those exceptions for subsection 6 and section 17 and 48 and 49. But the Act did not spell out what exactly the registration procedures and the steps to be followed and the legal consequences thereof would be when a sectional plan is cancelled by order of court. So just as a side note, we say there are exceptions. What are those exceptions? In other words, where you can cancel a sectional plan without having a court order. The first one, section 14 subsection 6, is where the developer owns all the units in the scheme. So none of them have been transferred, or if they had, he's now reacquired them. So only one entity or person owns all of them, then you can cancel without an order of court because you're not affecting anybody else's rights. Section 17.6 is where all of the common property is transferred. The technical, it's rare, I don't think it happens often, but it could. All the owners decided we're going to sell the common property, which effectively means the scheme is gone because you can't have a scheme without common property. The next one was section 48, which now has been repealed, so it's no longer relevant. But section 49, and you'll see why I mentioned that because it comes in later, is where a scheme has been destroyed, basically razed to the ground or deemed to have been destroyed totally, and where the owners have then decided not to rebuild. So what happens now? In those circumstances, you can cancel without an order of court. But now let's look at the amendment again in the context that we've just explained. So section 14 now becomes section 14.8a. Sorry, can we just ask you to mute, please? Whoever's not on mute. And then the new subsection is added, which says, okay, we've now said, you know, a sectional plan can be cancelled by order of court, but we haven't prescribed a procedure. So instead of now writing out a new 6 pages into the Act, what we do is we say, well, the provisions of section 49.3 to 5, those are the ones that set out the procedure when buildings are destroyed. Those provisions, we're going to copy and paste them. They will apply even when the cancellation is by means of an order of court, just with the necessary changes. So take those provisions, just adapt them and follow them. This is what this amendment means. So the conclusion, in a sense, is that the amendment, first of all, merely clarifies what should be self-evident. And the legal effect is that when a court cancels a plan, the procedure is the same, give or take, necessary changes, as when a sectional plan is cancelled due to the destruction of a scheme. And as we've said, destruction and damage to schemes are dealt with in section 49. So what are those legal effects and required procedures? I don't think it's all that necessary for us as developers and managing agents to know, but for those of you that want to know the detail, you'll find it on this slide. Basically, all of a sudden, where previously you were the owner in law of a unit, now you are the co-owner in undivided shares, according to your participation quota of the land. Mortgage bonds that previously attached to units now attached to the land. The land reverts to the land register. Sectional title unit title deeds must be surrendered. New certificate of registered title for the land will be issued. The old title deeds will be cancelled and so forth. That is the amendments to section 14. The next section we're talking about is section 15. There's only one amendment. It is also minor. It's to address a gap in the Act. It's merely procedural, so it's more of relevance to the registrars and conveyancers, but it's still important. And it concerns a situation where a section 25 right of the developer to extend the scheme has lapsed. Now, I'm sure all of you know the context and the way that section 25 right works. Just by way of refreshment, if a developer develops a scheme, let's say it's a large tract of land, you build 10 units, but you intend to build another 40, then you are obliged and entitled in terms of section 25, a very important section in the Sectional Titles Act, to expressly reserve for yourself the right to extend the scheme by building 40 more units, and it must be publicly known. And if you sell property before you've extended to purchasers, then that right of extension must be disclosed to the purchaser, because you can imagine, I'm buying into a scheme, I think there's only going to be 10 units, and meantime, the idea is over the next 20 years to build another 40 more. It's going to impact how I view what I've purchased, the merge. So it's important that real rights of extension are disclosed. But real rights of extension, in terms of the law, must have a deadline assigned to it. So there must be a time period that is registered in the title deed for the exclusive use right. So Section 25 rights can lapse. When do they lapse? One of two instances. Either the right has been fully exercised before the deadline. In other words, all 40 units in our example have been built, or it lapses because the time expired and it was not built, but now it's expired. So the minute that a right to extend expires, it falls back, the right then becomes, if you like, the property, it vests in the body corporate. Who's the body corporate? The body corporate is the association, statutory association, if you like, comprising the members thereof are all the owners in the scheme. Now, previously, before the amendment, there was no procedure mentioned in the Act when a right lapses for whatever reason. There was nothing in the Act that said how it had to be dealt with. And you can, it's a nuisance factor. Now, I'm a new purchaser. I want to purchase. I put my lawyer onto some due diligence research. The lawyer comes back and says, yo, I see there's a right of extension by the developer. And I say, I didn't know that. I'm not sure that I want to buy anymore. Then the developer says, yeah, but it's, or the agent says it's lapsed. And I say, how do I know it? I want proof. So there wasn't a mechanism previously in the Act that permitted the registrar or permitted a developer to request the registrar to say, please, or the body corporate or whoever's interested, please note against the title deed or against the documentation of the scheme that the right has lapsed. It's no longer valid. So now there is a procedure whereby, I'm going to just briefly read to you, the registrar must note the lapsing on the title deed, if available, where a right has lapsed. Word order is a bit strange. I would have started, if I were the one that drafted the legislation, I would have said where a right, respective reservation has lapsed, but they did it the other way. The registrar must then note the lapsing on the title deed of the right. Now, what is the title deed of a real right of extension? Some of you who are the attorneys would know. I'm not so sure if the developers who work with it would probably also know. I'm not sure about the managing agents, but just by way of a side note, when one opens a sectional title scheme, that is the time when you have to reserve your right if you want to extend further. And one of the documents that will then be issued on registration of that scheme is a certificate of real right to extend the scheme in terms of Section 25. And if I then at some point decide I'm not going to develop, but this valuable right I want to sell to another developer, then this certificate of registered real right is my title, and by way of a notarial deed of cession of such real right, the right will be ceded to the next developer, and that developer's title deed, her title deed, his title deed will then be the notarial deed of cession. So the registrar, whenever that right lapses, must then note the lapsing on whatever the title deed is, the certificate of real right or the notarial deed, as the case may be. Here's the procedure. On application by the developer, or if the developer is no longer in existence, the body corporate, and perhaps you can't find that title deed anymore. Too long it's gone, it's somewhere, don't know where. Then it's okay not to lodge the title deed, but then you must lodge an affidavit saying that it's not applicable. And then the registrar will make the necessary endorsements. Now we come to Section 17, where there are 4 amendments, and perhaps we can start with the context. Section 17 concerns the alienation or the letting of common property. So we have a scheme There's a large tract of land. We'll come to an example perhaps now, and we decide we don't use that land. We either want to subdivide, cut it off and sell that and use money, or we want to let it. But now, careful, when in terms of Section 17, the lease that we are talking about in this instance is not the casual 2-month or 1-year lease. A lease is defined in the Sectional Titles Act for purposes of Section 17 is a long lease. It's a registered lease for the duration of a period of 10 years or more, or for the life of a natural person. So we're talking about a serious commitment that we're now making. Just incidentally, nothing to do with the amendments, but there isn't anything in the Sectional Titles Act that expressly authorizes the trustees or the body corporate to, on short-term letting, let parts of the common property to outsiders. That's an interesting point, but we're not going to elaborate. We don't have time. I must get through the rest of our presentation. So because of the impact on owners' rights of long-term letting of parts of the common property, or even worse, the alienation of parts of the common property, selling it off, there is in the Act the requirement. It's very good, well regulated. And then there's, amongst other things, the requirement in terms of Section 17 that if you want to sell or if you want to let, then the procedure is you need the owners to have a unanimous resolution. This is now in terms of the Sectional Title Schemes Management Act. Plus, if there is a real right to extend, then you also need the developer's consent. So if the owners by unanimous resolution and the developer, both together, decide to sell the whole of the common property or a part thereof, then they can do that. And likewise, they may decide to let on a long-term lease. But whatever you do, you have to follow the procedures set out in Section 17. But there was a little bit of a gap in the laws. So the latest amendment adds words to Section 17(4)(b). The red is the amendment. So where pursuant to subsection 1, so in other words, we've decided to sell or let, but now we're talking specifically about leasing, about entering into a long-term lease agreement. Where pursuant to subsection 1, it is sought to let land, which forms part of the common property or a portion thereof, on which a section or a part of a section is erected, the registrar shall not register that lease unless it is made subject to any right which the owner of the section or part of the section may have. And here comes the addition, because previously the holders of exclusive use rights, which encroached on that area that you wanted to sell off, did not have protection, and neither did the holder of any real right. Yes, they had to consent, or rather we've just read 17(1), where you can see they may by unanimous resolution so alienate or let. But it was not expressly stated that when we now enter into this lease agreement with whomever is going to let it, maybe it's the hairdresser next door or the car wash business or whatever works in the context of our sectional title scheme, we don't need that property. We'd rather have the income from letting it. But it is now expressly provided for that in addition to jumping through all the hoops, that lease agreement must specifically in writing be made subject to the rights of the holders of real right in terms of Section 25, that's the developer, or if that area also contains exclusive use areas that are affected, then you also need to make that lease subject to the rights of those exclusive use holders. So just by way of an example, we're going to be very quick about it. There's Vista Sectional Title Scheme, 10 units. The members decide to let an area. Mr. X is the Section 25 right holder and the holder of exclusive use rights, Mrs. Y. So those rights must then be made subject. Let's read that amended section again. Where pursuant to subsection 1, it sought to let land which forms part of the common property or a portion thereof on which a section, a part or part of a section is registered, erected, the registrar shall not register that lease unless it is made subject to any rights which the owner of the section or part of the section may have, as well as the rights of holders of real rights in terms of section 25, that's the extension, and 27. Those are the exclusive use areas. Okay, another amendment to section 17, it's a small one, but it's a significant one. Previously, well, I'm now repeating what we've just read, but what was deleted, so we read what was added, the exclusive use areas, but what was deleted was, or a part of an exclusive use area. You can no longer, and that makes sense in law. I think it was wrong in law, my respectful opinion, to previously have allowed the cancellation of portions, parts of exclusive use areas. So that has been deleted from section 17(4) capital B small b of the Act. So now it reads, whenever in terms of subsection 1, it sought to alienate a portion of land on which an exclusive use area is registered, the registrar, we're now talking about alienation, not letting. You're going to sell off that land, you must cancel the exclusive use area. And no longer is it possible for you to cancel just that portion of the exclusive use area that encroaches or overlaps. You must cancel the entire exclusive use area. There's no more such a thing as cancelling part of an exclusive use area in terms of the law. So it's really just clarifying and rectifying, quite frankly, what is an error in the law. Section 17, what about the amendments to section 17 for capital C? By the way, I think most of you that work with legislation on a daily basis understands the numbers. As you know, acts of, for example, the Sectional Titles Act was promulgated, well, it was published in 1986 and it became effective in 1988. It's quite old, so things get added, things get deleted. And when you add things, you don't want to change all the numbering because we studied so hard. You know, I don't want section 17 now to become section 19. That will really mess with us lawyers' heads. So you keep the original sections, but how then do you number the ones that you add? In the old days, before I'd say the 2000s, they referred to Latin description. So if you added under section 17, another new section, you'd call it 17 bis, bis being the Latin for number 2, the second number 17. They've done away with that, so now they would call it 17A, capital A. Or if you change subsections, the same applies. So after section 17(4), there were insertions previously 7, so they called that 7, and it's before 17(5), so they called that 17(4)A, 17(4)B, 17, and now we are busy with amendments to the existing 17(4)C. I hope that makes sense. So what was deleted was the words, the provisions of subsection 4B shall apply with the necessary changes, and it was changed to say where in terms of subsection 1, it is sought to alienate a portion of land on which a real right of extension is registered, then, this is the addition, the registrar shall not register the transfer unless the registration of such real right or part thereof has been cancelled with the written consent of the holder. Just an example then, you are the developer, you hold a real right of extension, part of the common property, there was a resolution to sell, but you hold the right of extension on that property. There's no ways that that right or that portion can be subdivided and now sold to a new person subject to your right of development. It makes sense. It can't be, because how can you develop on somebody else's land if they've now purchased it for another purpose? So the law now provides that the registrar may not register that transfer unless your right of extension has been cancelled. Now, obviously, the developer would, you know, that it becomes a commercial matter of negotiation, what it is that you would want in exchange for the cancellation of your right. So much for the amendment to the amendments to section 17. Section 18, and we really have to hurry now because I think I'm going over my time. Just the context. Section 56, referring back to that, you'll see why now, of the Deeds Registries Act is really a cornerstone, an unsung hero of the South African economy, because that protects the investments of banks who make mortgage loans. And if banks didn't feel secure to make mortgage loans to people to buy property, well, it would be very difficult to buy property. So section 56 and section 57 also relates, but it's the same principle, so we'll just stick to the one. The basic principle is that the registrar may not allow a transfer of any land if there's a mortgage bond over it, unless that mortgage bond is cancelled. That's the general rule. There are a few exceptions, for example, insolvency. And of course, for a bond to be cancelled, the bondholder, the bank or the lender, will have to consent to that cancellation. So that gives the banks control and it gives them the security, because you're not going to consent to the cancellation of your bond unless you're being paid or unless the purchase price is being secured. Now, section 17 reads, the provisions of section 56 and 57 of the Deeds Registries Act will apply to the Sectional Titles Act. So they are now importing those same principles into the Sectional Titles Act without having to quote everything. They just say it will apply, because now we don't have to cross-reference between the two acts, and it will apply to everything, the transfer of mortgage units, mortgage leases, mortgage real rights, mortgage real rights of extension, exclusive use area, etc. All of those things you can't transfer or you can't cede unless the bondholder consents. But one thing was missing, where the bondholder's consent was not required. And the amendment to section 17 now rectifies that. You now also need the registrars prohibited from doing the transfer unless you also have the consent. If we're talking about the cancellation under section 17, this was now the one where we sold common property, but there's a unit on and there's an exclusive use area on. You cannot do that transfer unless you cancel the bond, any bond that exists over such a section or over exclusive use areas. And that, of course, means you now need the bank's consent to that cancellation, and only then will the registrar be able to transfer that part of the common property that's been sold, and the exclusive use area is now cancelled, and whatever mortgage section there was, that section is also, the registration is also cancelled. So the context we've just explained, you can read through that in your own time, and we have given you an example as well. So it's not necessary to go on with that. Then we get to the amendment of section 21, only one subsection added. Let's just give a little bit of context quickly. The developer registers a sectional plan scheme of 7 large units, 800 squares each. He registers the plan. So the plan is there, he can now start selling, but the market changed. He realized people want smaller units, not going to get good offers. No transfers have taken place. The developer is still the owner of all the units. And then he decides, I'm going to cut them all into 2. They'll make still beautiful, roomy 400 square units. And instead of 7, I'm now going to have 14. Lovely. I'll have a better chance of selling it. But now to make that change, you'll need to amend the sectional plan that's already been registered. So D will instruct his land surveyor, but section 21, which deals with the approval of plans by the SG, makes no provision for that scenario. And as we've said, in order for a surveyor general or a registrar to do something, they need authority. And if there's no authority in the Act, you can't do that. So previously, it was not, strictly legally speaking, possible for a developer to change his mind about what should be on the sectional plan once that plan has been registered. The new amendment fills that gap in the law. The blue is just to tell you that that's a reference to the Sectional Title Schemes Management Act. I think, if I'm not mistaken, we are referring to unanimous resolution there. No, apologies. In that case, it's just the trustees that must give consent. But the addition in 1A is the provision of subsection 1 applies with the necessary changes where a developer prior to the establishment of the body corporate, intends to subdivide his or her sections or to consolidate sections. So this gives authority to a developer to do something that could previously not been done. And that is to change his mind as to what should be on the sectional plan, to amend the sectional plan where he wants to subdivide or consolidate before having passed transfers to new buyers. So section 21, I think, is very relevant to developers. Section 22, and the three sections that I'm very briefly going to run through now all deal with the same principles. So section 22, section 21 now makes it possible to change your mind. And it says you can do it for subdivisions and you can do it for consolidations. The addition of section 22(1)(a) now gives body to that. It says, and remember 22 is only about the subdivision. So now we're first dealing about subdivisions. An owner, the general thing is, an owner may, after approval of a sectional plan of subdivision, apply to the registrar to register that sectional plan of subdivision. This is now an owner. And then comes 1A, which now gives body to what we've just seen in section 21. The provisions of subsection 1 refers to all the little procedures that must be followed and boxes that must be ticked, also now apply where a developer prior to body corporate establishment wishes to register a sectional plan of subdivision of a section. So it gives clarity and it prescribes procedures. There's also a new edition of subsection 22(2)(c) capital A. Now, important that we read that. Remember, now we're busy with the application. The developer has decided he wants to subdivide. He has his land surveyor draw the draft sectional plan. It is now submitted to the Surveyor General. The Surveyor General approves it. Now it must be registered in the Deeds Office. An application to the Registrar of Deeds for the subdivision of a section shall be accompanied by, and then it lists all the documents, copies of the sectional plan, the sectional title deed, mortgage bonds, etc. For us, it's important, the new edition, if there is a lease that applies to that property. Remember, lease always in registration terms means a long lease for 10 years or the natural life of a person or longer that has been registered. So you've also got to lodge with your application, if it's relevant, any lease or any other notarial deed with a servitude, for example, that's registered against the section at the time of subdivision, if it's available. You have to lodge that, otherwise you're not going to get your subdivision approved. Provided where that lease or servitude deed or whatever is not available, then an affidavit must be submitted by the owner or the developer, as the case may be, saying it's not available, and then the registrar will just endorse the deeds registry's copy of that lease or that servitude. Reference to partition transfers have been taken out. Again, it's quite important, but really just from a registration point of view, I'm not sure that it really affects developers or managing agents, so I'm going to skip over that. But if anybody is interested in learning about that, it is an important amendment, then we can talk about that later. So the purpose, just to summarize, of 22CA is to rectify omissions. It follows logically, and it is the gist of it is the original notarial deed of lease or of servitude must be lodged. The next slide is an example, but we've discussed it previously. I think you're very welcome to read through it on your own. And the new subsection 22A tells us that when an application is made by a developer, such application must be accompanied by an affidavit to the effect that at the date of the application, remember, this is a very important thing to be taken cognizance of by both developers and conveyancers and also agents selling to purchasers. So I've now decided to subdivide because it suits me much better. But the problem here is, just before I made this decision, when I still had the 7 beautiful 800 square meter size units, I sold one of them to Mrs. X. And she is, what's the English expression, over the moon? any Volker, as we would say in Afrikaans. She just has this visions of herself sitting, sipping a cocktail on that beautiful 800 square meter units, apartments, balcony, and so on. And she knows there's only going to be 6 other similar exclusive units. That's why she purchased. But what she doesn't know is that in the meantime, I, the developer, changed my mind. It's now going to be 14 units. They're going to be far smaller, a little bit cramped. I also didn't quite figure out the parking yet, so we're a little bit short of. Anyway, she bought, and now what? Isn't this change of mind on my part going to affect her rights? Yes, of course it is. And for that reason, Section 22(2)(a) has been put on the books, where an application for the subdivision in this case is now made. There must also be lodged an affidavit by the developer saying 2 things, important things. As at the date of that application, he hasn't yet sold a unit or donated or exchanged. Or if he has sold, I must now disclose in my affidavit, I have sold a unit to Mrs. X. So it has been alienated, but it was not yet registered in her name. And now I've changed my mind. The other 6 I'm going to subdivide. Then the developer must, in that affidavit, disclose in writing to Mrs. X that I have now made application for the registration of a sectional plan of subdivision. And then subsection B says a deed of alienation in which the subdivision has not been disclosed shall be voidable at the option of the acquirer. So when Mrs. X now, to her shock and horror, discovers what's happening, well, then she will have the right to cancel. I'm not sure. I would be so disappointed because I know this is going to be a beautiful development, but her rights are limited to then cancelling. Okay, I'm going to try and conclude very briefly. We've now dealt with plans relating to subdivision. So the developer, as we've seen, because of the amendments, may now, even before the body corporate is formed, change his mind, and there's now authority for the registrar to register plans of subdivision. The very same principles apply when the developer decides the opposite, not to subdivide, but to consolidate. Principles are the same. I'm not going to deal with, repeat the principles. So you're very welcome to just read everything relating to Section 23, but there are no differences to what we've just discussed in relation to the subdivision. So subdivision, consolidation is what we're talking about. Let's get to the amendments to Section 24. Now, again, we're almost dealing with the very same thing, except now we're not talking subdivisions, we're not talking consolidations of units, we're talking extensions of units. So this is, as you know, I have a 500 square meter unit, but there's a lovely little area. It's actually common property, but nobody uses it. In fact, it's a closed balcony. It's common property, but I'm thinking, you know, if I just put a door and a window, it will be lovely. It could be another bedroom. So that is what is technically known as an extension of a section. As you know, if I'm going to extend a section, it means that I'm stealing part of the common property. So in order for me to be able to incorporate part of the common property into my unit, there are a lot of legal hoops that I have to jump through as an owner, and that is dealt with in Section 24, extension of sections. But there was again a little bit of a gap. So what happens if the developer now sees that balcony, says, you know, maybe I should have made that a bedroom. It would, you know, I could get more money for this. But he's already registered the sectional plan. So now again, same as what we've just dealt with in the case of subdivisions and consolidations. If a developer wants to change, amend a sectional plan by extending sections, it can now be done before the body corporate has been established, and the procedure for that, same principles that we've discussed so far, is then added to Section 24, which deals with extension of sections. I'm not going to dwell further on Section 24. If you have any questions, you're welcome to contact us. Then there's a new Section 24(6), but again, you can read all of that. 25 is the section that deals with extension of schemes. That is the developer's real right to extend a scheme, to build more units up vertically, horizontally, whatever the case may be. This section is probably, as far as I'm concerned, the most, or one of the most important in the Sectional Titles Act. And I was quite, when I looked at the amendments, I was thinking, now what's going to change here? Because there's a lot of challenges, both from the perspective of a developer who is frustrated in certain circumstances, and from the point of view of owners who sometimes have to put up with developments that do not meet with their expectations or what was registered as part of the Section 25 right. But that is an entirely different seminar all on its own. I'm not sure if I was relieved or disappointed to see that the amendments that were affected to Section 25 do not address any of those issues. Like most of the other amendments in this Act, it was basically technical things to improve, to fill gaps, etc. So there's not much controversial here. We can just very briefly go through it. Now, the context we've just discussed, a developer who has a right may extend the scheme by building. You can, for those of you that want the technical stuff or the legal stuff, you can read through on your own. What was added, something that really is just a side issue, but it's still very important. I don't know how many of you have had occasion to try and look for documentation relating to the extension of a scheme and then find that the file in the deeds office is empty. There's nothing. So there was no procedure in the Act. One had to rely on the Deeds Registries Act, and then it was sort of makeshift to replace lost documentation in that sectional title register. So now the amendment says that if any documentation is lost, this is now the documentation relating to extension of schemes. What the developer may build, how much he may build, what materials he's going to use, etc. If those documents are now lost, then the registrar must, on written application by the body corporate, or if there's not yet a body corporate, then by the developer, and in a prescribed form, and Regulation 25 to the Act prescribes the detail of what should be in the forms, etc. Then on that application, the registrar will issue replacement documentation. So again, administrative, nothing profound in terms of developers and their practice, but extremely useful and also quite important from an exam point of view for those young conveyancers that are, or aspirant conveyancers that are going to write. So what has also been added, if a right reserved in the real right of extension is exercised, this was made to force, just the context, developers are obliged, once they've now erected, they've exercised their right by putting up the stuff that they've said, or phase of the stuff, you have the right to put on another 50 units, and you've now built 10. You've completed them, so this phase is completed. You are obliged by law, in terms of 25, and it's been on the books for a while, to immediately after the completion apply for the registration of your plan. Now, why would a developer, if I were a developer, I would not want to, because the minute that it's registered, I'm the owner then of a unit, no longer of a real right of extension, I have to start paying levies. So I would like to delay that as far as I can. It would just make perfect commercial sense. But the Act obliges you now to register, and then there are other clauses, other sections, which says, and by the way, if you then don't do it, when you should have done it, you are deemed to have registered, and you're liable for levies anyway. But what was missing in the Act was that it also relates to the completion of exclusive use areas. So now it also forces a developer, once the exclusive use areas have been delineated and completed, you also have to apply for the amendment, for registration of the amended plan. Okay, 25.6, the addition, if there's been no reservation, or if a reservation is lapsed, we're talking about extension, then it vests in the body corporate. And the body corporate may, if they want to, reserve that right anew in favor of the body corporate, the members, the owners.
And that's lovely because now you have a right that's valuable. You can sell it to a new developer. Previously, the only procedures in the Act were you, the body corporate, may now reserve that right. And here we have our title deed. But now, before we must exercise that right, because it was realized that, other people have interests that might be prejudiced if we're now all of a sudden cede this right to whoever we think should buy this right. Now it is said, provided that the body corporate shall only exercise, build it ourselves, alienate, sell the right, or transfer such right. The transfer follows on the sale. With the written consent of all the members of the body corporate, the mortgagees of the units, all mortgagees of units, and the holders of real rights over the units. Sure, I'm not sure if we as a body corporate will ever then be able to sell this right, but one can understand why you need the mortgagees, because it affects their rights and it affects the rights of other holders. Then fortunately, the last bit was added, which says you need their consent before the body corporate can now alienate this right. But these stakeholders, the mortgagees and the holders of rights, shall not withhold such consent without good cause in law. So that helps a little bit. Right, new section 2510C. I think it's fairly self-explanatory. I don't think we need to read that, but you're welcome to ask us. It just relates to what documentation must be lodged. Now, mortgage bonds, which previously was not necessary in such a case, must now also be lodged, and together with the consent of the mortgagee. But please read that and let us know if there's anything that's missing. The red in the square brackets are just things that were removed. So these were amendments which made a very vague term. You had to do something about any mortgage bond which may be affected by. That was replaced with the words registered against. Because what mortgage bonds are affected by something? We're talking about specific mortgage bonds, those ones that are registered against over the real right of extension or over the exclusive use area, etc. Apologies for going a bit faster, but I'm already way over my time. So I'm going to conclude with section 21, extension of schemes by addition to land. It's the very same principles that we have already spoken about. So I'm not going to make any further comments. Again, let us know if there's anything you need to know. And the same with rights of existing rights of exclusive use areas. Perhaps I can just draw attention to section 5A. The provisions of subsection 5 apply with the necessary changes to the cancellation of a right to exclusive use or part of the common property registered in favor of a developer. So same principle as we've said, you realize, oh, you want to change the plan because you want to rather subdivide or you want to consolidate or you want to extend sections. The same now applies if before the body corporate is in existence, you want to change the layout of a registered sectional plan where it concerns exclusive use areas. No need for us to repeat the general principles there. Section 45 is just the sectional titles board. There should now be 2 conveyancers advising the minister on regulations, etc. And then lastly, section 55. This is just to eliminate sudden surprises. If the minister is going to make regulations in terms of the Sectional Titles Act, he can't publish them and say they are immediately valid and enforceable. He must give notice of at least a month in the Government Gazette before those new regulations will be implemented. And that, ladies and gents, everyone, is the conclusion of my part of the section. Thank you for your patience and for being with us. It is now over to Maryna.
Good afternoon, and it's lovely to co-present with Lizelle, and thank you, Lizelle, for the lovely introduction to the changes to the Sectional Titles Act. The The changes that she mentioned are already in force and therefore very important that we know it in detail. I'm going to take a tiny bit of time in addition to go through provisions that are anticipated in the Housing Consumer Protection Bill. It's more by way of an overview, and I'm not going into the details. As soon as this bill becomes a law and is enacted, we will go to every effort to explain the details of it to you, because it's pretty important to estate agents, to developers, to anyone who does home renovations. So let me just, in 2 slides only, explain to you where this piece of anticipated legislation is heading. The bill is pretty close to becoming a new piece of law. It was passed in the National Assembly in December last year, and once I think all the FICA changes have now finally been incorporated, because government was quite busy with that, and also now the tax legislation that we heard of yesterday, once all of that is in place, they will focus attention again on these outstanding pieces of legislation that needs to be, or that they want to enact. So I'm confident, and the industry seems to be confident, that within the next 6 or so months, this bill will become a law. Why in a developer context is this important? Because of the fact that it seeks to repeal an act that you know very well, the very long named Housing Consumers Protection Measures Act. And we know that one well because that's the act in which the NHBRC was established, a regulatory council for builders in South Africa, and which also established a fund to give relief to owners who had, or housing consumers as they are called, who had homes built for them that was substandard building, and that there's some relief for them to claim damages if the builder didn't repair the defects in the building work. We also know that for developments, the builder, the developer, had to register with the NHBRC, and then in addition enroll every home to be built with the NHBRC. And the registration and enrollment isn't only a paper exercise. We know that you have to pay money to get those enrollments and registrations done. The idea behind the receipt of the payment is, of course, to create this fund from which housing consumers could be compensated where required. You also know that this is a piece of legislation that says it's an implied term of an agreement between a builder and a housing consumer, that there's certain warranties in place. We're aware of the one that deals with major structural defects. It's a 5-year warranty. It may not be shorter than that. For non-compliance with plans and specifications, 3 months after the housing consumer is moved in. And then the last one is the roof leaks. There's a 12-month implied warranty, or it may not be shorter than 12 months, that the builder will repair any roof leaks if those leaks result from non-compliance with regulatory provisions. What does the new act do to this picture? Briefly, to do a comparison, for the first time, they have included a definition of a developer. So the bill has a definition of a developer specifically, and a developer is someone who initiates or undertakes a project to build a home. If I initiate a project, I don't even build the product, but I'm an initiator. Then I'm a developer, and I fall under the auspices of the new act. The old act only had one definition for a home builder, and the home builder is someone who carries on the business of building, of home building. So there's a big change, because in this new, with the act that will come into operation, we've got a developer, and now we also have a home builder, and a home builder under the new act is the person who builds a home for himself or for others, and or builds a home for on-selling or for renting. These changes to the definition of a builder comes because there's been lovely judgments, and they all went, or many of them went to the Supreme Court of Appeal, where builders said, there's one lovely instance where the builder said, listen, I'm building these houses, but it's for myself. I'm not going to rent it out. Therefore, I'm not going to sell it. Therefore, I'm an owner builder and I'm entitled to rely on that exception of owner builder. That they weren't successful in court, but the current act isn't clear enough on that. And those changes in the definition definitely addresses those bits that were unclear. And in that regard, it is a good change. Also, it specifically mentions that if the developer is a trust, he can also be seen fall into the definition of a developer or a home builder, again, because that comes from a Supreme Court of Appeal judgment where the builder of a sectional title scheme said, listen, I'm a trust. The act refers to person, so I don't have to register because a trust isn't a person. And the Supreme Court of Appeal said, listen, we're pulling at the ends a bit, that can't work so, but the current act isn't clear, and it had to revert then to a court to come to the solution, so or to assistance of the housing consumer. So with the changes in the new act, these little loose ends are clearly tied up, but it's extended it because, as I said, the definition of developer is wide. It's a person who undertakes or initiates a project to build. He's not even building at that stage. He's just part of the thinking. And that brings him within the auspices of the act. The other thing that is quite important, I thought, was that the current act applies to home building. It applies to the activity of home building. The new act says it applies to when I build a new home, so it's where developers very often are involved, but also applies to any activity in respect of a home that requires municipal approval, specifically home renovations, alterations, changes. If it's of such a nature that it requires municipal planning approval, that is activity to which this act applies. Again, this goes much wider than the previous act, because the previous act specifically concentrated on building a new home from scratch. Also, the act says specifically, if I have an existing building, which is commercial, and I'm going to change it into a residential building, that activity will bring me within the application of the act. Then the deemed provisions. I mentioned briefly earlier that the deemed provisions that we are very aware of at present, those were retained. It has to do with the warranties, and those are similar in the bill and the Act to be, except with a little bit more detail. Your warranty in respect of roofs, that is at present a 12-month warranty, is extended and it's now 24 months. The other two time periods, the 5 months and the 5 years for structural defects, and the 3 months for small nitty-gritties and not compliance with the plans, 3 months, those remain the same. But in addition, they say it is a deemed provision that the builder is registered with the council and that the home has been enrolled. Now, the current act doesn't have that deemed provision, and it had the effect that, and again, this is case law, Supreme Court of Appeal judgments that had to confirm this. The current act says if the homing consumer, the person who has the house built for him, doesn't employ a registered builder, he cannot rely on these warranties. He doesn't have access to the warranties and the protection measures of the Act. So if his roof leaks within a month and it's because of shoddy building work, he's got no recourse to the funds held by the NHBRC. In order then to force housing consumers to use registered builders, the Act says the builder cannot institute an action in a court, claim funds from such a housing consumer. So if the housing consumer stands back and says, I'm not going to pay, then the builder cannot succeed with a claim against such a housing consumer. But if a housing consumer doesn't know of this, he's really left stranded and he cannot access the protection that the Act was trying to achieve to give to him. That changes because the Act now says it's a deemed provision. The builder is registered, the house is enrolled, and therefore my housing consumer has access to the funds that the NHBRC holds, that monetary fund, if the builder doesn't perform in terms of the contract and doesn't use the right materials and cannot fix those problems himself. The registration aspect remains important. So all builders, whether or not I build a new house or I do renovations, must register with the council. In addition, the council must prepare a public register of builders, and that public register is planned to be a bit of a nasty register, because the builder, if he's had previous findings against him, if there were complaints by the public against his building works, and the council, after investigating, found that those are valid complaints, there will be a mark against his name, and that will be shown on the listing on the public register. In addition, on this register, this public list, developers and builders will be graded in accordance to the amount of finances they have available to finish bigger projects. Can they do big projects? Can they not do big projects? And the like, what infrastructure assistance they have. So that will become an important thing, because there's a public register where you will be graded as a builder and as a developer. The provision that the man in the street, the housing consumer, may not appoint as a builder who's not registered with the council remains. But again, this prohibition is now bolstered by the fact that it's in any event deemed in favor of your housing consumer that your builder and your developer is so registered. So the good news there is, as we've mentioned, is that my housing consumer then has access to the funds that the NHBRC holds in case where he suffers financial losses as a result of shoddy building work. Lastly, the enrollment aspect. We know that in a new development, homes must be enrolled, and that has remained the same. So only for new homes to be built, the enrollment requirement is there. At present, if I do renovations or alterations to a home which requires municipal planning building work, it's not required for those projects to be enrolled with the NHBRC at present, but there is a note in the Act that the minister may decide to the contrary and decide that these other types of building work, we know that the builder must register, but that project must also be enrolled. That is a change from, obviously, from the current position, because current speaks only to erecting of a new home. And then lastly, you will know that, or be aware of, and conveyancers will be very, very aware of the fact that when we receive an instruction at a conveyancing firm to register what we call a building bond, which relates to a bond for the building of a home on a piece of land, there's a requirement that we have to ensure on behalf of the bank, but also for our own purposes, that the home has been enrolled and that builder is registered with the council at present. In that way, there's regulation that a person cannot access a loan, a formal loan from a financial institution, if they did not ensure that the building project is in the hands of registered builders. So that is quite important as a protection measure, again, for the consumer, because that forces them to work with registered builders. They've gone in the proposed new Act and expanded on that. And they've pulled in more conveyancers, and they've pulled in we refer to as estate agents, but in the Act it refers to as property practitioners. And estate agents are part of the definition of property practitioners. But they say there that an estate agent must make reasonable effort to determine if the home or project he is busy selling is one for which enrollment is required. So they must make sure whether or not it is a home that is being built from scratch by someone who's a developer or a home builder as defined in this Act. And that is a responsibility placed fair and square on the shoulders of the agent himself. In addition, they said that conveyancers must, apart from attending to the bond side of the transaction, so where you have a bank that gives you an instruction in respect of a building bond, that we verify that the builder of that project is registered. The conveyancer doing the transfer does not do exactly the same thing. So the Act says if you do the transfer of a home, you must ascertain whether or not that home is part of a building project for which enrollment was required. So there's a very substantial and additional requirement on the shoulders of conveyancers, both on the mortgage bond registration side and the transfer side, to ensure that you work with registered builders and homes that are enrolled. And then similarly, as in the past, the new Act says a bank may not make money available as a loan for someone or for a building project if they haven't ensured that the builder is registered and the home is enrolled. I'm going to leave it at that, and I'm going to stop our screen sharing. It's been a lovely session, and I know perhaps slightly longer than Lizelle and I intended, but it's lovely. And there's just so much information and new things out there. And I think it's important for us as SDBB to keep you updated and keep you ahead of what's happening, what's coming, what has changed. And yeah.
Thank you, Maryna. I think this was fascinating. I heard all of this now for the first time, and for me, I was really pleased that I could do that. Thank you, everyone, for joining us. As Maryna says, this is our pleasure. We really enjoy preparing for these sessions. We enjoy the law that is part of it, and we certainly enjoy the exchange of information with colleagues and associates and others in the stakeholders in the industry. Hope you have a good afternoon, and we see you next time.
Just before we say goodbye, I see we haven't answered all the questions on the side or any at all, and we will look at them now afterwards and send you responses as far as possible if we have the answers. But making the recording available, yes, I think our marketing team will make the recording available, so they will send it to you afterwards.